Thank you guys for coming. I know the next panel is a little tough after lunch, but our moderator is Omar Hakim, who will be him and his panel will be discussing raising EB5 funds, issues to keep in mind.
Hi. So I am the corporate and securities attorney at Mona Shah and Associates. This panel is going to focus on securities and compliance issues, integrity measures, things like that. Things you need to keep in mind when you're doing your offering to make sure you don't get yourself in trouble. We have a distinguished panel here, and first of all, I'd like to thank Baruch for hosting this event. I'll let everyone do a quick self-intro here, starting with Kurt.
Thank you. Thank you, Omar. My name is Kurt Royce. I am a co-founder and principal of EB5 Diligence, and I'm also a broker-dealer representative with Primary Capital in New York.
Hi, my name is Dawn Laurie. I'm a partner at Polsinelli in Washington, D.C., and I'm an immigration lawyer focusing on compliance in the EB5 space.
Hi, my name is Clem Turner. I'm the senior partner in the New York office of Homeyer & Law. We have offices in New York and Los Angeles. We've been doing EB5 deals since 2009, and we represent regional centers and issuers and developers and help them navigate the securities laws in connection with their EB5 offerings.
Good afternoon. My name is Julia Park. I'm the managing director of AAEB5 Group. We own and operate 4 regional centers, one in New York, Northern California, Nevada, and Hawaii. Separately, we have under a separate umbrella EB5 broker-dealer called Multivista Securities.
Hi, everyone. I'm Nemo Corpivaro. I'm a partner at David Herson & Partners. We're an immigration law firm based in Los Angeles.
Hi, I'm Harry Almquist. I founded Valerian Capital, which is an opportunistic real estate fund platform, a big component of which is the match pairing of development bridge mezz with EB5 takeout.
So there are a lot of stories about troubled projects in the news, with the latest being JPEAK. What are some of the lessons that we can learn from these projects? We'll start with Nemo on this one.
Oh.
No pressure.
No pressure.
Yeah, wake up.
You know, the question of why do projects fail is not exclusive to EB5, right? In any one of our neighborhoods, you can walk by a storefront, a business, a hotel that was unable to survive for whatever reason. I think if you look at EB5, where it started and where we are now, it's certainly become more institutional. Institutional level due diligence, institutional developers, no conflicts of interest between your regional center, maybe your issuer, and your borrower. I think for what we try to look at when we do a due diligence on a project is where's the risk, right? I think you have 3 types of developers. You have a developer that has everything lined up. Their financing is lined up, the contractor's lined up, they have their permits, they're ready to go. I'd say we feel more comfortable that the project will move forward and, not a situation that we've heard about in the news. You have some developers that maybe they're not all lined up, but they've been doing this for 50 years. They know what they're doing, they have a reputation. Then you have some developers who are new in the space. They have every good intention, but they don't have their ducks in a row. And they get delayed for whatever reason. They lose a senior lender. They have to find a new one, and things just start spiraling sideways. So I don't even know if I answered your question. But
Don, do you want to jump in here? Yep.
That's
Sure.
It sounded good.
sounded good.
No,
That's all that really matters.
well, I think for me, I would make a distinction between a troubled project and then a troubled project for immigration purposes. So when we look at projects from a compliance or due diligence perspective, my role is just looking at it from the immigration perspective. And in that, we want to make sure that the individual investors are going to be covered on the jobs and the business plan makes sense for immigration purposes. I think people have to separate out, what might be a good project first and then what might be a good project for immigration purposes. But talking specifically to your question about the trouble projects, I think what we saw here is a failure of monitoring and compliance, particularly in the most recent JPEAK space, along with many of the other cases that we're seeing that the SEC is targeting. I mean, we have a misuse of proceeds where the proceeds are not being tracked, the investors' funds are not being tracked correctly, and there is no monitoring and transparency. So I think the space has really matured. I did my first EB5 filing in 1993, and it is an entirely different world, mainly really in the past 4 years. And like you said, Nima, I mean, it's become institutionalized. So if things are done correctly and the right monitors and compliance processes in place, we hopefully will see less of these troubled projects. Unfortunately, though, in my crystal ball, I think we're going to see a lot more of these failures in the next few years until things get better.
Does anyone else have any thoughts on this issue? All right. So we're hearing a lot about new compliance and integrity measures, both from Congress and then maybe from USCIS itself unilaterally. What does the panel see coming as far as compliance and integrity measures? We'll start with Clem on this one.
Thank you. I had the opportunity to study the integrity bill in depth, working with IUSA. Peter Joseph was here. He spoke this morning. We've prepared, IUSA has prepared comments on that to help the lobbyists and give them a sense of what we as practitioners think is important. I think the biggest benefit in the integrity bill is addressing what I hear the immigration lawyers saying is a lack of ongoing monitoring, a lack of auditing of these projects. For many, many years, and when we got involved in EB5 in 2009, when we heard about diligence, it was primarily, and what investors were concerned about was primarily, will this project get me my green card? Does it have the job numbers and what have you? And recently, with the failures, I see a lot more agents, I see a lot more investors concerned about the controls in place at the project. I see a lot more investors and agents concerned about the real estate bona fides of the project, the people involved, and you hear a lot more questions in the last, I would say, 2 to 4 years, but certainly in the last 2 years, about those kinds of things. And the integrity bill is going to make an ongoing reporting obligation of regional centers with respect to securities matters, compliance matters, diligence matters, as well as material change. Has something materially happened with the project? And then of course talks about catastrophic things like bankruptcies. But the goal is to get more information into the marketplace in a timely manner, and hopefully that will raise the bar that is currently set for EB5 projects.
Kurt, what should regional centers, projects, and investors be doing now to prepare for any upcoming changes?
One of the challenges with the integrity bill is there is no integrity bill yet. There's a proposal out there. I chair a group of 11 securities attorneys. We're called the EB5 Securities Roundtable, and we have been working on the integrity bill to make it what it seems to be trying to accomplish. So we've made edits to it, and when I talk about the integrity bill, I typically talk about where I think it's going to be, not where it is. I think the whole role of the regional center is going to be significantly adjusted here. And I think that you're going to have them acting more in line with what you'd normally see in a broker-dealer role. Some of the items that they're requiring certification from regional centers include background checks on the people that handle the money, compliance with securities laws. I could stop there for a moment because we don't know what the securities laws are, or at least there's a lot of disagreement as to what the securities laws actually are and what they mean. A lot of people are raising money based on an issuer exemption, which really hasn't really stood the test yet of whether or not the SEC is going to accept that. And when we see some of the actions that are coming out right now, the SEC has started with unregistered broker-dealer activity. But I would suspect that they will continue down the chain of items that they can pounce on. So to ask a regional center to to certify that everything is being done in a compliant manner with securities laws, and they're going to, without being a broker-dealer, they're going to be asked to do something that they really don't have the competence in, and they're going to be overseen by USCIS. this immigration service that doesn't know anything about securities laws either, I think we're in for a bit of a challenging time, but it's also an opportunity. And maybe regional centers will start to realize that their role is more or less bringing a compliance officer into their organization. And that might be an opportunity for regional centers to grow more quickly and maybe aggressively if they can get their ducks in a row.
Could I add to that?
Sure.
Yeah, I think I've heard people tell me that they're using the issuer's exemption, and I ask them who their securities lawyer is, and they don't have one. The issuer exemption is actually incredibly complex, and for most of it, you actually need a broker-dealer, which a lot of people don't realize, but if you just read it, you would see that in there. So I just wanted to echo that point, and hopefully the bill will get people who still don't fully understand the securities ramifications of EB5 to realize that it is something that's important.
Donna, do you want to jump in here?
Well, actually, I was going to ask Julia. I mean, what are you all doing now? Because I've always seen the role of a regional center as a gatekeeper. I think people used to be very upset with me for saying that, but I think pretty much we're going to be on that page now. What are you all doing?
In terms of the compliance piece,
Right. Are you
gatekeeping
rolling anything out now, or have you already had compliance processes in place?
Yes, we hired a whole full-time person for compliance to start. We have an attorney just dedicated to compliance. We also went through the process of setting up a broker-dealer, which was recently approved. I think the issuer's exemption, although very complex, does provide a lot of breathing room for regional centers, and we have, up to this point, been hanging our hat on the issuer's exemption because we are the co-manager or the manager of the issuer of the NCE. So for us, we have been hanging our hat on that, but we've been uncomfortable, which is why we spent the time and money to go through the broker-dealer process. The compliance issue, especially in the context of integrity bill, I think really becomes more tricky when you talk about what we call in the industry like rent-a-center models or leasing of regional centers. I think if the regional center acts as the manager of the issuer or the co-manager, there's a lot of control that we have. The issue becomes when the regional center is leasing out the license and there is a separate issuer and manager, what can the regional center do? And that's a big issue for us right now. I'll be very honest. We have a handful of lease deals, and up until, say, 6 months ago, we were just making sure that they weren't doing anything wildly inappropriate, and then they were paying us on time. Now, we're going to visit them. We're having monthly calls. We're sending out questionnaires. Saying, where are you on construction? Send us your loan closing documents. So the integrity rules or the proposed rules definitely is putting a lot of pressure on regional centers to step it up. But the current version as it stands, I think, is going too far.
Agreed.
It's putting issuer liability on a regional center, which is really, not always the issuer. And I think that's why a lot of industry professionals like Clem and IIUSA and all of us on the IIUSA Public Policy Committee are really trying to tweak that.
Yeah, agreed. And I was just going to follow up with the comment. From a best practices perspective, there's still so many things that a regional center can do to still oversee and monitor. As you said, I mean, in the rent-a-center model, you still can have that co-management, that oversight. But again, at the end of the day, I do agree that it's gone too far. I think what regional centers have to understand is this is a business that requires commitment, it requires capital, and it requires a long-term vision and resources. And I think part of the problem that, quite frankly, the USCIS allowed for, and Nima, I know you can certainly agree with me on this, is they approve things they should have never approved. So we're starting to see an uptick in
I think I know
terminations.
the case you're thinking about.
Exactly. I think we have 53 terminated centers, and I guarantee we're going to have more soon.
And one thing, and jump in, is so this is only for regional centers, right? This idea of strict liability, which is essentially what they're doing, is for regional centers. So if anybody in the world that is under your umbrella of the regional center commits an SEC violation, you as the regional center are responsible. There are still issuers in direct investments that they're not placing this burden, if you want to call it that, on, which is interesting.
Yeah. This was something that Julia and I did try to address the
eavesdropping.
markup.
I eavesdropped,
Exactly.
yeah. Right.
Julia was on the committee with me, focusing on the securities laws with specificity in the markup, in the markup of the integrity bill. I wanted to throw something else out that occurred to me that I think is also going to be huge and potentially game changing, that I don't hear much talk about. But under the new integrity bill, which I don't think we touched, I don't think you guys touched it either, there is a requirement that the investor be given disclosure on everybody that is receiving a fee in connection with that investment and the amount of that fee.
See,
Which-
you don't talk to me enough then, because I talk about that all the time. Nothing wrong with it.
Right, exactly. And broker-dealers have that obligation now, and you also have an obligation to keep your fees reasonable. And I'm very, very curious and hopeful that this kind of fee disclosure could have a positive effect on the migration agent community in other countries, which currently doesn't necessarily share that information with investors. And I think investors need to know that information. That's why it's part of our regime here.
Yeah, and that could lower fees for the developers. As agents have to disclose what they're making, it may make for a more transparent marketplace. So that could be a positive effect on us. One question I've had for securities attorneys for a long time is, why don't you do more than you do? And the answer is, well, because the client doesn't want to pay for it. And why doesn't the client want to pay for it? Well, because there's no profit that we charge too much. Well, the reason there's no profit is because the Chinese agencies are often taking 4-5% of the profits each year. And so as they have to disclose those fees, I think that you're going to see the potential investors start to use the internet, start to use other resources to learn about projects and probably move the market.
What should a project or a regional center do to protect themselves in case a migration agent, says they disclosed a fee, but through fraud or whatever, actually didn't? Is there anything that they could
Well,
do?
I think in the bill, the disclosure gets signed by the investor and has to be a part of the investor's application.
Right.
So I don't think there's that option. But
Wouldn't it be put in the offering then? I mean, wouldn't you have to put it in the offering documents if it was?
well, the problem has
Not
been
known at the time of
right.
the
The problem has been at the time of the offering, and you can speak to it.
No.
Like, not a chance.
Why would I?
Understood. Okay.
Supplement.
Please.
Well, you'd be updating that constantly. The problem at the time of the offering, you have no idea who your agents are going to be, and we negotiate those kinds of deals, and so there's sometimes sliding scales, and
Right.
you really have no idea what the fees are going to be. So what gets disclosed now is a range,
Right.
and that's less than ideal from a SEC perspective, but it's
Right.
necessary because in fact you don't know. However, when the investor has signed and written a check
Right.
and has officially subscribed, you do know who you have to pay for that investor,
Right.
and so you can very easily then create a disclosure schedule.
One of the people in my panel brought up the fact that what the legislators want to do more than anything is not disadvantage Americans and American agents to foreign agents. And American registered advisors or agents must disclose their fees, and they must communicate that affirmatively with the client. So the client needs to know what is being paid to the agent. And I think that this same concept is going to absolutely, I believe, be enforced across foreign agents. And I think that there is no skirting this. I think there has been some talk as to, well, would somebody who doesn't speak English be able to understand what they're signing? And I think that it would leave the issuer in a very dangerous position if they had any kind of playing with this regulation.
But related, if they provided the certification in English and they signed it, and they still didn't understand it. Is there any way to protect against
Well,
that?
I mean, California has a law that says you have to understand what you sign. So,
Right.
so it's not enough just to sign it. So, I mean, how is a lawsuit going to result? I don't know. I don't want to be on the other side of that.
Right.
And it seems like a difficult threshold to definitively prove, right?
Right.
Sure.
So are there any other proposed measures that anyone on the panel is particularly for or against?
I'd say one thing, right? So regulation, right? When you hear about project failure, bringing in regulations is great, right? One of the things that was originally in the Senate reform bill was FBI clearance for anyone that's going to get a regional center. I don't know how many of you have ever applied for FBI clearance, but it takes a year, right? And in every case that I have applied for someone, I've had to sue the federal government to get it done in 4 months. I don't know, Don, if you have the same experience. So when your developer is like, okay, well, I want a regional center, I want to go to market. And I say, okay, well, it's going to take me a year and a half to get you clearance and then another year to get your regional center. And they respond, well, my permits expire in 6 months. What do I do? It's, it's the same reason USCIS doesn't do TEAs anymore, because when they did, it took them 6 months to give you a TEA letter, right? So it's not just a matter of, okay, let's get these regulations to protect the investors. And one of the protections they have in the bill that was released 2 weeks ago was checking investors' Facebook. But who is going to implement this? Is it USCIS? Is it their domain to even do this? Is it the SEC? They're already overburdened, right? So what is the proper application?
To move on, we're hearing more and more about the redeployment of funds to meet the at-risk requirement. What should issuers, projects, and investors be doing now to prepare? I'll start with Harry on this one.
I'm extremely, extremely excited about the potential strategic implications of redeployment. For those of you who are not familiar, there are a number of projects that are really going to be heavily impacted by the fact that the retrogression cutoff date for Chinese applicants is February 15th, 2014. That means effectively that the $15 billion or so of EB5 that's been raised in the interim have not even begun to be processed yet, especially given the amount of fundraising infrastructure that's entirely predicated upon China. This is going to create a number of issues, both going forward for fundraising, but also for those projects that will be looking to recapitalize or monetize sometime in the next few years. I would say especially those with condominium projects. But really, they're, USCIS, you may hear this a few times today, but they haven't been enormously transparent in providing guidance about how really that they expect it to work. What we have received from them thus far is really that they're really not going to accept the JCE repaying the NCE, only for the NCE to place that money into some escrow money market fund or treasury bill. As of right now, it's still quite vague, but it seems like the general industry consensus, please correct me if I'm wrong, is that you really may actually have to look towards redeployment into other at-risk projects. The reason for my excitement is that you're going to have a number of projects that have 175 million or so of EB5. Well, USCIS is not going to really allow them to divvy that up and reallocate it to multiple smaller projects. There aren't really going to be that many people that have both the understanding and the ability to assume large sums of EB5 and then redeploy it.
Don, you have some thoughts here?
Well, so just to, promote myself for a second, the reason for my excitement is we're getting there eventually, but don't worry.
Hog's gonna let
I'm
us see
tying
you.
it all back together. It's going to make
were
sense, I
gonna-
promise. Stick with me. Is that we're focusing on offering an EB5 fund vehicle. Historically, the question has always been, which project do I choose and why? I hope to invalidate that, because why would you ever want to take on 100% asset and therefore job creation concentration risk? We have 3 New York City projects, average capitalization of around 400 million. Thankfully, 2 of my developers are here today showing me the support and hoping to get some feedback of whether or not I'm full of it. But
So,
leave
we
it
could
to
use mutual funds now, right? It's just hard to count the jobs. So I am not so excited for redeployment in certain circumstances. I mean, I've had clients that have wanted to use redeployment, and we've been knocking at the USCIS's door before retrogression with the query of as long as we were disclosing the specifics of redeployment, let's say in a condominium situation where we have the money available, and if everything was outlined with as much detail as possible in the offering, the original offering, would it be possible? Then, retrogression came. So as an immigration lawyer, I'm just looking at a whole slew of issues, let alone the business issues. I mean, CIS is not in a position to be monitoring these redeployments. Sometimes, they talk at these stakeholder meetings, talk amongst themselves. I have no idea what they're talking about. So, and they're well-intentioned, but to talk about redeployment, how are we going to deal with Chinese nationals in the same funds as, let's say, a UK national or someone from Vietnam or Latin America, where they're going to want their funds out at a certain period of time, and they've created their jobs and they're done and they have their green cards, by God, they're citizens by this time. And so are we going to have to bifurcate funds and have, retrogression, and that's
yes.
fine. The problem is that the service, CIS is not sophisticated enough to handle this. And we have, as I said, a lot of problems coming down the pike with projects that are not going to repay funds. Maybe they're going to get their 829s. Maybe they're going to get their 29. We're starting to see lots more denials because the service is much more savvy now. We have a fraud detection unit where we have site visits, and it's a new day. So we're so busy with this, and I think if we as an industry want this program to continue, we have to, I don't want to say be a little less greedy, we have to be more practical. I mean, we have to be that too. So, I mean, the idea of I think it's a great idea, but I don't know if it's for every project. I don't think it should be mandatory on in a perfect world.
Clem,
just-
I know you have some thoughts
Go
on
ahead.
how it interacts with the Investment Advisors Act.
Right. If you wanted to talk about.
Can I go first?
Okay. Yeah.
Because I just want to
tell
take,
us, how do you want it?
I want to take a step back because I feel
corner.
like this is a mixed audience, and some of you are like, yeah, redeployment, no, and some of you are like, what are they talking about? So let's just take
Oh,
a
I
step
thought-
back.
Right.
Yeah,
No,
let's
good
just
idea.
take one
Yeah.
step back. So here's the issue. It takes your conditional green card period is 2 years, and then 2 years later you apply for an I-829 to remove the condition. It used to take about 6 months to get your immigration petition approved. In other words, it used to be that when an investor invested in EB5, they would be done with the whole process in 3 to 4 years. That's why it was very market for EB5 financing to have a 5-year term, because the investor's money has to be at risk for the duration of the whole process. So you're done in year 3 or 5, you wait a year or 2 and you get your money back. So this was not an issue. The issue today is because of the Chinese visa backlog. To make a long story short, Chinese people will now be getting their money back or getting their I-829s approved in anywhere between 6, 7, or 8 years, depending on how the backlog goes. So we now have an issue where people's immigration petition is outstanding for 8 years, but the investment term is done in 5. So what do we do in year 5? Can we give these people their money back? No. Can we hold on to the money and keep it in the bank? That's what we want to do as a regional center because that's the safest thing. But the USCIS is saying no, that doesn't meet the at-risk requirement. So you need to redeploy these funds for that gap period of 2 to 3 years so the money is at risk. And that creates a whole host of issues, securities issues, investment issues, immigration issues, because people from Brazil will be done in year 3 or 4. Are they going to have to keep their money in for 8 years to accommodate for the majority of Chinese investors? So that is the backdrop in which we're discussing this.
Right, but they haven't said it yet.
They haven't said it yet.
They're
They
thinking about it.
Well, we know that they're not going to let you just keep the money. They want you to do something. But is it okay to keep it in a money market account?
Well, Angela Pepperelli
Right.
asked that during a thing,
Or
and they said
does it have to
possibly.
go into a bridge fund, like lending club for, that kind of.
Hopefully not lending club
Oh, yeah,
style.
I love lending club. I love lending
The
club.
overall point is valid, yes.
But or does it have to go into like this active investment fund where it's actually being so this is the gamut in which we're trying to do our deals now until the USCIS gives us guidance.
And if you see,
And so-
sorry, I didn't mean to cut you off, Clem, but you see the silliness of this, right? Where you have this integrity bill, regional center strict liability, issuer liability, all these things to protect the investor, when really what is hurting the investor is these processing times and delays, right? So you're going to tell me as a regional center, I have strict liability, but then it's okay to say that I'm going to cycle this money 6 times without approval from the investor? I mean, that's crazy. And the other thing that doesn't get brought up is this idea of material change. that if you materially change your business plan from what you originally filed with USCIS, material is not defined by USCIS, you have to refile. And this material change runs until you get your green card. So for a Chinese national, that means the project cannot change for 7 years, right? Every project is going to change. What if your senior lender changes, right? What if you have to change your interest rate? And then the question gets posed to me, is that material? And I say, I have no idea. And they go, but we're paying you. And I go, thank you.
But then probably.
But I have no idea. And so if my answer is, if you want to be safe, refile, well, the investor says, well, my child already aged out. If we refile, the child isn't getting the green card, right? So this, the integrity bill is window dressing.
Well,
I
it's also-
actually find, let me jump. I actually find the USCIS, I was going to say definition, but it's really a lack of definition of materiality, just completely mind-blowing as well. I mean, there's a very long and well-articulated securities law.
Case law.
Yeah, a rich case law in the securities realm as to what is material, and what isn't. And so when a client asks me, is that material, I can say yes or no, most of the time. And if it's maybe, then it's yes. So, no, it's shocking. And I just want to throw, another more gasoline on the whole redeployment question, because when we do a deal now, we build redeployment. I said retrogression, I meant redeployment. We build a redeployment mechanism into the governance documents so that we'll use the shortcut word regional center. We've been saying regional center, but what we
You should
really
say
mean is
sponsor,
the
so we're
issuer,
inclusive
the
of everyone
sponsor.
there.
But I'll continue to say regional center, so I don't want
Shut
to I don't want to get you all bogged down in vocabulary. So we build a redeployment mechanism so that the regional center actually has the power to redeploy if that's necessary. But for older deals where this wasn't thought of, the only way that you can redeploy the capital under deals that we did 2-3 years ago is to get consent
Yeah.
from arguably every single investor, but at least the majority of these investors, and my understanding from regional centers, is that is not necessarily the easiest thing to do.
You might want to engage the migration agents at that point, right?
Right. So, we've, from a securities and corporate perspective, we have baked retrogression language and mechanics into the documents, and we've also taken great care to prevent any regional center implementing that from falling under the Investment Company Act of 1940, which would be a nightmare if that happened. But
I can
for
solve
older
the
deals,
problem. I got a solution. Kurt? So,
I'll let you
okay,
speak
so
to it.
let me first just mention that, so I'm part of EB5 diligence, and Dawn was writing and asking me, what do we do when we look at the offering documents in this issue? Because you want to have the flexibility to redeploy because we don't know what they're expecting from us. And yet, as a due diligence representing investors, I don't like to see that flexibility given to the manager or to the developer to control the funds. I want my investor to know what the outcome is going to be. So we actually point out both of those cases in every report because we don't know which one's better, but we want the investor to understand what their options are. And this is, by the way, the report that we produce. Now, in our securities roundtable group, we did meet with the Grassley and Leahy staffers, and we came in with the approach that we're a technical resource. We did not have a dog in the fight. We did not opine about TEAs or any other issue. We tried to clean up the integrity bill. But we did add one little section, and it's called at risk. And we defined at risk to say the term at risk means exposure of capital to a chance of loss and opportunity for gain, however great or modest, so long as not nominal or sham. And it goes on for another paragraph. But effectively, I think by coming in with as a technical resource to the staffers who I think will drive the integrity bill, I think this will be added to the integrity bill. And if it is, we avoid the Investment Company Act issue, we avoid the redeployment issue, and it's just one paragraph that I don't think anyone's going to have a problem with. So hope that that's what happens.
All right, to move on.
Sure.
Just move. He's done with us.
Because of retrogression, we're seeing a lot of interest in having minors make the investment directly to avoid aging out. Is this permissible, and if so, what steps should an issuer or regional center take to make sure that the subscription is valid? I'll start with Clem on this one.
Okay. Sure. From a corporate perspective, it is permissible. However, there is a problem, and I think there's a problem from an immigration perspective, which I'll tee up and then toss it to you guys. So, from a corporate perspective, you can have a minor sign a contract, and the problem is that that contract is voidable once that minor reaches the age of majority as governed by their specific state. So, 18, 21, whatever you want to call it, based on the state. From a corporate perspective, minors have been signing contracts for years specifically in the entertainment industry where, you're hiring an adult can't play a 5-year-old. And in other instances. But in that situation, you'll have the parent sign a guarantee of that minor's signature so that if the minor does void it at age whatever, the parent is on the hook to indemnify any damages and essentially is guaranteeing that signature. And that works from a corporate and securities perspective. What has recently occurred to me and what I'd like to get your opinions on is I always thought that for an I-526 to be filed, the purchase of the investment had to be irrevocable.
Right.
In order for the I-526 to be mature enough for the Immigration Service to rule on it. And so, I wonder in that regime, the fact that it is voidable, and from a corporate perspective, we've only just shifted the risk of that voiding from us to the parents. And so for the most part, it's kids' parents probably not going to have an issue. But from a very, 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 very technical perspective, I'm curious if you guys think that solution works.
Right. So the issue is it's kind of similar to a redemption clause,
From an
which
immigration perspective.
USCIS has said is not allowable. And even though it's not in the document specifically, if USCIS gets technical and has expertise to figure this out, they might say the I-526 cannot be approved because
Right.
of this.
Now, having asked that question, I actually know that they have approved
Right.
some of these.
Right.
So there's also that.
Right.
So don't worry if you're accepting minors.
Well, I guess
Don't
the
worry
one.
now, anyway. Until next week when they.
Yeah, I guess the one issue is whenever they bring
When
in
they
new
change their
employees, they might change their mind. Does anyone else have any thoughts on this?
I have a question, Clem. Is it every state that at the age of maturity you can void a contract, or are there states that that's not the law?
I believe, well, I'm only barred in 2.
Okay.
But I believe it's every state. It's a pretty ubiquitous
But can't you have it?
concept.
Well, first of all, isn't it also in the state? Because we have to worry about, it's not just in the state, it's also in the country, so, and in the province or wherever it is, right? So maybe you're in, I don't know, where in China, and you can be 16, right? You
Well,
can do
the
it.
securities documents are usually governed by some state's law.
Okay.
New York, in your case, obviously, a lot of them are governed by Delaware.
Okay.
So there's
But that's the jurisdiction which would govern this question.
So if you then said to them, when you turn, and I'm not advocating this, when you turn, the age of majority, you have to then reaffirm, right? That, and that's part of the agreement that the parents are making. Then let's just say you can get around that. I'm going to tell you about another issue that I have, the management issue, right? So you're going to have the 526 is going to come up, and we have 13-year-olds and 14-year-olds now making investments. We're having issues with escrow, but but we're getting around this.
KYC a 13-year-old.
Yeah, well, we're having issues.
He's got a bus pass.
Well, and that's a good point, right? Because in most countries, if you're under 18, you can't open a bank account.
Right.
So that means you need.
Yeah, so we're getting it. Okay, so
parent.
even if we can get through that, then what's happening is, even though the individuals are not coming over, the 526s are coming up for adjudication when the kid's maybe going to be. Oh, I haven't had any yet, but the kid will be what, 14 and a half, 15. And then at that point, is it the parents that are going to be stepping in? I mean, look, it's not something that I particularly want to bring up for the service, and maybe they're going to, because you're right that they've been approving them. I haven't seen that young, but we've seen 17, 18. So when they start to realize the age of these kids, I don't know. I don't know what it's going to be, but it's a problem. At the end of the day, we need more visa numbers in this program. That's everything goes back to visa numbers, and this is an
I can talk a little bit about what we are doing for our investments. But before we begin, let's frame the issue again for some new people. So EB5 is an immigration program, but the underlying investment is obviously governed by securities law because it's a securities vehicle. It's a securities investment. So we have two regimes of law that we need to be cognizant of. The question that people ask all the time is what's the rule for USCIS immigrant? There is no rule. I don't know if it was an oversight, but the USCIS, the immigration laws specifically do not state how old an investor has to be.
Right. But a stakeholder meeting, they actually said either in the state or
But the immigration piece, on the federal law piece, there's no age limit. But the question becomes, what about the underlying contract, the investment? Can a minor sign that? Why are we even talking about this is because of the China visa retrogression. When a parent files an I-526, as long as the child is under the age of 21, no matter how old the child is, by the time you get the visa, the child still can get the green card under something called the Child Status Protection Act. However, if the delay is caused by a backlog in visa numbers, which is what's happening with Chinese investors, you don't get benefit of that act for a certain period of time. In other words, we were talking about backlogs of 3-4 years now to get a conditional green card. So 2 years ago, if your child was 19 and you did a green card, that was fine. Now, if your child is 19, you have to be concerned, then by the time we get our green card, will he have aged out? Will he not be eligible to get the green card? And that age is getting younger and younger and younger as the backlog grows bigger and bigger and bigger, and people are getting calls for I have a 13-year-old. Will you accept him? The answer to that on the contract side is really, you talked about the entertainment industry, which is very fun, which is very interesting. But to us, if you're under 18, you're under 18. We don't care if you're 17 or 11. You're under 18 legally. However, the really hard part about EB5 is that this is the USCIS adjudicating, and the USCIS is not. They're not like they're not like the IRS. With the IRS, if you find a loophole and you can make an argument that this is, they will concede. Okay, we'll go change the law, but we'll let you take your tax deduction. With the USCIS, if they don't like something and they can't hang their hat on it, they'll find another reason. Right. They'll just find another reason to deny you. So this is the difficult environment in which we're operating under. We talked about materiality. I just saw a denial where the USCIS claimed that there was a material change because the investor number went from 12 to 13.
Wow.
So that was a material change. It was mind-blowing. But you could obviously
that would
tell.
actually be material from a securities perspective because you're changing the amount of the raise and you're diluting the 12 investors.
But you know
with
what?
another
They
one.
only had 12 investors, so that's a whole nother story. But you could tell that was not what they were hanging their hat on. They didn't like it because the developer took out a big chunk of equity, and
he's replacing it with it.
Yeah, and so but they didn't like it, and so they talked about it, and we don't like this, but we're denying you because you have a material change. So this is the difficulty of USCIS. So back to the underage issue. So what we're doing is we haven't yet accepted 13, 14-year-olds. I've gotten investors who were underage when they signed approved. That's very common. But for the investor questionnaire, we're having the parents co-sign as the purchaser rep. For the immigration petition, the child will sign. For the operating agreement and subscription agreement, previously, we just had the parents co-sign, But now we're taking it one step further and we're having them sign an affidavit outlining exactly what Clem was saying, which is because our concern is what if the USCIS wises up and says this petition was not approvable at the time of filing, and the fact that the child will reaffirm at 18 doesn't matter because at the time of filing he wasn't 18. So, and if we get into that argument, we want something to hang our hat on, so we have the parents sign a guarantee saying that we're going to step into the shoes of the investor, and no matter, regardless of what immigration says, we're going to be on the hook for the investment. And Clem's question was, and so my answer to Clem's question is that's what we're doing. In answer to your question of is that enough, we don't know. Right. So we don't know, and the best thing we can do is tell the investors this is the current situation, and this is the risk that you are taking, and mostly they will go ahead because EB5 itself
It's less
is
risk than there than the
it's
risk
less
of getting
risk
aged out.
than the aging out,
aging out
which
risk
is
is
almost a 99% risk if your
Right.
child is 18.
All right, I think we need to wrap up here.
Can
We'll
I
open
just
the-
say, I
go
think
ahead.
it's safe to conclude from this that after this panel, none of us will be receiving Christmas cards from USCIS. So.
We'll open the floor to one or two questions.
I have a question regarding the integrity bill. When the fees to the migration agents or whoever is receiving reimbursement for attracting investors, how is that made public and who is it made public to?
There's no mechanism in the bill to make that public now. That disclosure is something that the investor gets when the investor makes their investment decision. However, the investors don't have that information at all now. So you would presumably hope and expect that investors, would talk about that information, or at least would ask questions about that information at the closing table. And you would also certainly expect for migration agents, if they were proactive, if they wanted to get ahead of any potential issues, they would make that known so they didn't have a closing day impact, and it's maybe something that they might even market on, you would hope, in the future. Right now, all we can do is guess, and all we can do is look at the U.S. broker-dealers and how they work as a model, and say, well, they disclosed and this is how it works now. But I'll let Kurt or Julie follow up if they have more to say. But to answer your specific question, it isn't actually made public. It's just made known to the individual investor.
Yeah, I think it's fair to say disclosure happens when the investor puts it on WeChat.
Right.
What I have is not so much a question, but an observation. Picking up on comments from this panel and other panels about the sophistication of the investors and referring to them almost as if they were regular U.S. private equity investors who are doing their due diligence. This is entirely anecdotal, but as an immigration lawyer dealing with clients who are interested in EB5 and speaking to others, there really isn't any level or at all of sophistication on the part of the majority of clients. To start with, it's a pool of people looking for a passive, minimal investment who are primarily driven by trying to get a green card. And my question, I guess, to the panel is it correct to speak of the high level of sophistication of investors, especially since I'm sure when the integrity bill comes to Congress, the committee will have a whole parade of farmers from Hunan province who mortgaged the farm and lost it. So I'm just wondering if something can be factored into account for the lack of sophistication of so many of the potential EB5 investors.
Julia, the regional center, I think that's for you.
Well, I wasn't on the previous panel, or I wasn't here for the previous panel, so I don't know the context of which it was discussed, but we do talk a lot about how investors are getting more sophisticated, et cetera, et cetera. I do have to say that when we talk about it, we're not actually talking about the investors because we go through migration agents. So it's more that the migration agents that we're working with are getting more sophisticated in screening projects. So before, if you had an EB5 project, because there weren't that many and it looked okay, For example, I recently saw a denial for a project. It was just incredible. They took the money, bought computers, bought cars. I mean, it was an incredible project, and it got denied. And I sent it to my partner, and it had like 12 investors in it. And the deal itself was very messy. And I sent the denial to my partner. I was like, "Can you believe what these guys did?" And he said that his reply was, what the most shocking part about that denial is that 12 people actually signed up, not that there was fraud. You know, so that's how unsophisticated people were, many years ago. But a few years ago. But the thing is, it's not the investors per se. When at least, and I can't speak for everyone, but when we speak, it's more the agents. They are screening out more projects that don't comply with the requirements. They're more concerned about issues like redeployment, about securities issues like broker-dealers. So I can only speak for myself.
I can say to that, we actually had that realization as a securities, I'm a securities attorney. We actually had that same realization a few years ago. And a few years ago, we actually shifted our form disclosure document, which I'll call a PPM, a private placement memo. We shifted that from the legalese kind of traditional Regulation D PPM to a plain English PPM, which looked more like a public company disclosure, in order to make the disclosures in that more accessible to somebody who didn't necessarily have a law degree or was used to finance. And hopefully that had an effect. We don't know, but at least we are now drafting things for regional centers that if they're faithfully translated and handed to an investor, they should at least be able to understand what we're saying.
This concludes the panel. I'd like to thank everyone for participating.
Thank you.